Good morning, dear colleagues, partners and friends from all over Ukraine. As ever, I have already seen who have activated their cameras. I see colleagues from SLS, the familiar team, from the Ministry of Economy, from trade unions, and I also hope that we have here representatives from employers. We are happy to see you on this beautiful summer day. This is the fourth training of our online marathon. European and international labor standards. And today we are going to speak about something very important, part-time work. And also we have prepared several surprises for you, and Antonia will provide you with more detail. Traditionally, I would like to briefly present the agenda for today. I am now going to show the slide with the agenda. As you can see, we start with Antonia's presentation. It will last until 11:45. Then we will have case discussion. They have become popular and they help us to better understand the standards that we are discussing. And then we have prepared a bonus presentation. It is telework presentation. Again, we are going to have several cases. Then we will present our website and we will show where you can see our information resources. We will hear your questions, we will respond to them. After that, we have another bonus, another small bonus. Since there was high level of interest to maternity protection, we invited for just 5 minutes Andriy Figal to present this topic because he is now the leader of the respective components in the ILO project. And then we will have this voting feedback in order to have actually a feedback on our webinar 4. And then we say goodbye until the 5th webinar on Labor Inspectorate. This is the agenda for today, and pass the floor to Antonia Santos, project manager, team leader. He has been looking forward to saying hello to you and switching to his presentation. Antonia, you're welcome.
Good morning, everybody. It is a pleasure to address you from Zatoka Beach in the Odessa region. As you might see, this is fantastic. This is really one of the advantages of telework, which, by the way, is one of the bonus that we prepared for you today. As you know, this marathon of online trainings on international and European labor standards includes 6 modules. The first one we had it on the 25th. It was on employment relationship. Then we have the second on the employer's obligation to inform workers on the main aspects of the employment relationship and to ensure transparent and predictable working conditions. Then we had another one. The third one was on working time. It was held last Thursday, 9th July, and today we will address another component of part-time working time, which is part-time. But we prepared another module, which is telework. Why? Because telework is also a very important instrument, a flexibility on labor relations. It allows to balance the needs of both the employers and the workers for a more flexible working relationship arrangements. And this is particularly true on this context that we are living in with the outbreak of COVID-19 and the increased use of telework as a means to ensure physical distancing. It is really a way in which we are able to prevent the exposure of workers to coronavirus contagions within the workplaces and elsewhere, because the coronavirus once is in the workplaces, it can be, of course, transmitted within the workplaces and out the workplaces in our personal life, with our friends, with our family. So telework assumed recently a huge importance as a management tool and as a tool to manage workforce and to prevent the contagion of coronavirus. That's why we are addressing today also, besides the foreseen module on part-time, we are also addressing the telework. And of course, this marathon will not finish today. We will have another module on labor inspection, which will be the fifth one that will take place on the 23rd of July, and the final one, the last one, will be held on the 30th of July, and will be focused precisely on occupational safety and health. So thank you so much for joining us. We are happy to receive you back here, and we are really happy to see that we can have a steady number of participants in our online trainings. As you know, the main objective of this summer marathon of online trainings is to improve the knowledge, skills, and capabilities of the policy decision makers and the legal acts drafting experts on international and European labor standards. We expect that the increase of their in-depth knowledge of these standards may support the better alignment of the national legislation with those standards, as foreseen on EU and Ukraine Association Agreement. However, during these sessions, we will not comment any specific national laws, nor will we comment the alignment of the Ukrainian legislation with the international labor standards or with the European Union directives. That exercise will be left entirely to you, and we hope that this knowledge that we are sharing here today will help you to do that exercise. So let's start, and let's start with the presentation on part-time. So as you can see, part-time is not more than a work that is carried out in a period which is shorter than the one that is usually performed. It corresponds to a normal working period or average period of work over a period of employment, not longer than 1 year, which is shorter than the one that is practiced in a full-time work in a comparable situation. It can be performed only a few days per week, month, or year, and the number of working days and working hours should be established by agreement. The advantages of the part-time work regime are obvious. For employers, for one side, they will have more flexibility on the organization of the work. They can more easily manage the working time. And it also helps to adapt the work demands to the workers' needs. For employees, on the other side, as you can see on slide number 4, it helps the employees to balance their work with their personal and family life responsibilities. It also helps to promote the access to labor market of workers with family responsibilities. And also, it is specially adapted to vulnerable groups of workers, including workers that are undergoing education or training, older workers, workers with disabilities, etc. But of course, along with the advantages and the opportunities that part-time offers, there comes also some problems. And that's why it is so important to regulate part-time at national level. First of all, there is the problem of the discrimination of part-time workers in relation to full-time workers in a comparable situation. And that discrimination also, we can find it regarding the rights to organize, as you can see on slide number 5. The rights to organize, the rights to bargain collectively, and to act as worker representatives. The part-time workers can also be discriminated in what regards their right to have safe and healthy working conditions, on maternity protection, on the right to be trained, on the issues regarding the termination of employment, or even on the rights to annual paid leave, public holidays, sick leave, etc. Other problems regarding part-time, as you can see on slide number 6, has to do with the non-application of the principle of pro rata temporis when defining the remuneration of part-time workers. because as the international labor standards and the European Union acquis foresee, remuneration and other benefits of the part-time workers should be calculated on the basis of the remunerations and benefits of comparable full-time workers on the proportion of the working time of the part-time workers. So that is the principle of pro rata temporis, and not always this principle is followed. Other problems are obstacles that are put to changes between full-time and part-time work, or non-voluntary transfers from full-time to part-time or vice versa. Other problems that we can find regarding part-time is the non-provision of information to part-time workers regarding the essential aspects of their employment relationship. Sometimes also part-time is used as a way of partially undeclared work, and that occurs, for example, when an employer and a worker declare only half of the income of the worker, alleging that the worker works part-time and not full-time, whereas he works really full-time, and half of the remuneration is not declared. And also, there is other problems that are related with the access of part-time workers to social security protection. And that's why International Labour Organization and the European Union define some international labor standards on part-time work, as you can see on slide number 7. They include basically the ILO Part-Time Work Convention of '94, which, by the way, was not yet ratified by Ukraine. This Convention 175 is really one of the most important working time conventions of the ILO, besides the hours of work convention and the conventions regarding the rest and annual paid leave, as we have seen on the previous module on working time. Also, a very important international instrument is the Council Directive 97-81, which is a directive focused on part-time work, and that approves a framework agreement on part-time work concluded by the European social partners. And according to the EU-Ukraine Association Agreement, Ukraine should approximate national legislation to this directive by August this year, by the end of August. And there are also 2 other directives of the European Union that address part of the issues concerned with part-time, in particular the obligation of the employers to inform part-time workers about the main aspects of their labor contract or employment relations. This Directive 91-533 and Directive 2019-1152. We already addressed these directives on the second module of our online trainings. So we are going to go through the main provisions of these international labor standards. Part-time workers should receive the same protection as the one that is affordable to comparable full-time workers. And that means regarding the rights to organize, to bargain collectively, or to act as worker representatives in matters of occupational safety and health working conditions, and also regarding non-discrimination in employment in occupation. These provisions mainly address the right of the part-time workers not to be discriminated in relation to the full-time workers. And in particular, to ensure that part-time workers do not receive a lower proportional basic salary than the basic salary of comparable full-time workers, just because they are part-time workers. Other provisions of this convention, ILO Convention 175, has to do with is focused on ensuring that part-time workers have conditions equivalent to comparable full-time workers, of course in proportion of the working time, in which regards maternity protection, termination of employment, and paid annual leave, paid public holidays, and sick leave. And there is another very important principle that is ensured on this Convention 175 and also on the framework agreement on part-time, which is that transfer from full-time to part-time or vice versa should be voluntary. As for the Council Directive 97-81, it foresees two main principles: the principle of non-discrimination between part-time and full-time workers, and the principle of pro rata temporis. They are crucial. The first one, of course, is the one that we have already seen on ILO Convention 175, and it just states that in matters of employment conditions, part-time workers shall not be treated in a less favorable manner than comparable full-time workers solely because they are part-time workers, unless, of course, a different treatment may be justified on objective grounds. So it means that they cannot be discriminated because they are part-time workers. There might be other objective grounds that might justify difference of treatment, but those justifications cannot be grounded on the fact that they are part-time workers. And another principle is the principle of pro rata temporis, which basically states that the remuneration of part-time workers and other benefits should be proportional to the working time of part-time workers, should be calculated on the basis of the remuneration and other benefits of comparable full-time workers in the proportion of the working time of part-time workers. And there is another important provision on the Council Directive 97-81, which has to do with the fact that if a part-time worker refuses to be transferred to full-time, or a full-time worker refuses to work in a part-time regime, that should not constitute a valid reason for termination of the employment relationship. Because, as we have seen on ILO Convention number 175, the transfer from full-time work to part-time and vice versa should be voluntary. Moreover, as you can see on slide number 11, Council Directive also establishes some employers' obligations regarding part-time work. First of all is that employers should consider workers' requests for being transferred from full-time to part-time, or from part-time to full-time, or to increase working time. Employers also are responsible to provide timely information on the availability of part-time and full-time positions within the undertaking, in order to facilitate the access of workers to either part-time or full-time positions. Employers also have the obligation to facilitate the access to part-time at all levels of the undertaking, including skilled and managers, skilled workers and managers. They also have to facilitate the access by part-time workers to vocational training. And they should also provide appropriate information to existing bodies representing workers on part-time work. As for the Directive 91/533 and the Directive 2019-1152, that employers are required to provide to part-time workers, as to all workers, information about the main aspects of their employment relationship. And that information should be provided regarding several issues which are considered essential aspects of the employment relationship. Some of them are here on slide 12. Identities of the parties, place of work, title, grade, nature or category of work, date of commencement of the employment relationship, and its end date or its duration in case of the employment relationship is concluded for a fixed term, duration and conditions of the probationary period, if there is any probationary period, the remuneration, not just the initial basic amount, but including other elements which should be stated separately, as along with the frequency and the method of payment of the remuneration. Also, on the employment agreement, or in the information that should be provided in writing by the employer to the workers, it should also be mentioned if the work pattern is entirely or mostly predictable, the length of the standard working days or week, with comparative reference to full-time work in case of if it is a part-time employment relationship, and also if they are foreseen overtime arrangement and shift arrangement. Moreover, if the work pattern is not predictable or is most unpredictable, well, employers also have to inform workers about the work schedule in concrete, the reference hours and days within which the worker may be required to work, and the minimum notice period to work to the worker before the start of a work assignment, and also the deadline within which the employer might cancel the work assignment. In addition, Directive 2019-1152 also foresees, as you can see on slide number 13, some mechanisms, early settlement mechanisms and legal presumptions that are aimed at protecting workers and increasing the transparency and the predictability of the working conditions. And these mechanisms that are foreseen on this directive include, for example, the possibility of the workers benefit from favorable presumptions, which of course employers shall have the possibility to rebut. An example of that is, for example, the inclusion of a legal provision on national legislation that foresees that, for example, when an employment relationship of part-time work is not agreed in writing, for example, it is presumed that the employment relationship is concluded for full-time, as happens in several European Union countries, for example. Or the possibility of the worker to submit a complaint to a competent authority or body and to receive adequate redress in a timely and effective manner when his rights are violated, or when the employer fails to provide the information to the worker on the main aspects of his employment relationship. Other mechanisms that are foreseen on this directive include the access of the workers to effective and impartial dispute resolution mechanisms and the right to redress in case of infringement of their rights, and also measures that protect workers from adverse treatment and for any adverse consequences resulting from a complaint lodged with the employer or resulting from any proceedings initiated with the aim of enforcing compliance with their rights. So these international labor standards in the European Union legislation have some implications when it comes to transposing these international labor standards in the European Union acquis to national legislation, and in particular to Ukrainian legislation. One of the most important aspects is to define the concepts. It's important to know that we are talking about the same issues, that we are calling the same, that we are referring to the same realities when we are talking about the part-time work or a comparable full-time work. In this case, a part-time worker should be understood as an employed person whose normal hours of work, when calculated weekly or on an average over a given period of employment, are less than those of a comparable full-time worker. Whereas a comparable full-time worker should be understood as a worker who has the same type of employment relationship as the part-time worker, which is engaged in the same or similar work or occupation in the same establishment, with due regard being given to the seniority, qualification, or skills of the part-time worker. And where there is no comparable full-time worker on the same establishment, these comparisons should be made with reference to any existing applicable collective agreement, or where there is no applicable collective agreement, it should be made to reference to national law, collective agreements, or practice. Another implication for policy decision makers and law drafting experts in Ukraine when it comes to institute a part-time work regime in national legislation is the attention that should be paid to the need to ensure that part-time workers are duly informed and timely informed about the main aspects of their part-time work employment relationship. And in order to do so, one of the easiest way is to foresee on legislation that obligation, and that can be fulfilled, for example, if it is foreseen on the legislation that a part-time work employment relationship should be done by in writing, should be made a part-time work employment agreement. And in any case, either via part-time employment agreement or via the need to provide information to workers in writing, the main important aspects of the part-time employment relationship that the workers has to be informed about are the ones that are displayed on this slide number 50. Identity of the parties, place of work, category of the work, category of the worker, or a description of his work, the start date of the employment relationship, and in case of fixed term part-time work, its duration or end date, the duration and conditions of probationary period, if any, entitlement to training, amount of paid leave or the way to calculate it, procedures for terminating the employment relationship or reference to the legislation that provides that information, the remuneration, if the work pattern is predictable, the weekly work schedule with comparative reference to full-time work, and this is very important. And in addition, any arrangements for overtime or shift arrangements. When the work pattern is mostly unpredictable, it should be foreseen on the part-time employment agreement or in the information that the employer should provide to worker, the number of guaranteed paid hours and the remuneration for additional hours in relation to these guaranteed ones, the reference hours and days when work may be required by the employer to the worker. And it is important to note that it should include a comparative reference to full-time work and the minimum period of notice before the start of work and the deadline for its cancellation by the employer. Also, it should include the applicable collective agreements, if any, and the social security institutions that will receive the contribution. Moreover, to ensure that national legislation includes a legal provision foreseeing a legal presumption of regarding full-time work. It should be foreseen then whenever the employer does not provide in writing to the worker all the information on the most important aspects of the part-time employment relationship, either by a labor contract or by one or several written documents, it should be foreseen that in that case, when the employer fails that obligation, it shall be presumed that exists a full-time employment relationship between the concerned part-time worker and the employer, or whenever there is no reference, comparative reference on that information, on that written information given by the employer to the worker of his working time in reference to comparable full-time workers. Moreover, it should also be provided for in the national legislation, as you can see on slide number 18, that part-time workers may not have less favorable treatment than the full-time workers in a comparable situation, unless different treatment is justified for objective reasons, which should be defined or which shall be defined by collective agreements. This is important because this would institute the principle of non-discrimination of part-time workers in relation to comparable full-time workers. And also, in order to ensure that the pro rata temporis principle is applied when it comes to the calculation of the remuneration and other benefits that the part-time workers are entitled to, it is also important to foresee that national legislation establishes that part-time workers are entitled to the basic remuneration and other benefits provided by law or collective agreement or where they are more favorable to those received by full-time workers in a comparable situation, in the proportion, of course, of the respective normal weekly working time. Moreover, it is also important to ensure that the legislation foresees or facilitates the access to part-time and from part-time to full-time and vice versa. In this regard, it is important that the legislation foresees that part-time workers may be transferred to full-time work or vice versa on a permanent basis or for a specific period by a written agreement with the employer. And also, it is also important to ensure that where the transfer from full-time work to part-time occurs for a shorter period or a specific period of time, the worker are entitled to resume the provision of full-time work after that period. Legislation should also provide that, where possible, employers are required to take into account the employee's requests to change from full-time work to part-time work available at the establishment. That also employers take into account the employee's request to change from part-time to full-time work or to increase their working time. And in general, employers should be required to facilitate the access to part-time work at all levels of organization, including management position in the high-skilled workers. In addition, legislation should also foresee that employers should provide workers in a timely manner with information on the part-time and full-time jobs available in the establishment in order to facilitate the application of the workers to those positions, and should also provide employees' representatives with the adequate information on part-time work in the organization. This is pretty much what I foresaw to share with you regarding part-time work. I will pass the floor to Sofia Letvan to consolidate and to apply the theory that we have seen before. Thank you, Sofia. Over to you.
Thank you, Antonio. And I believe that we should wait till Q&A. We have here 3 comments that we should comment on now, I believe, while it is relevant. So first comment from Yuri. He comments, I believe it is about your slide 14, that standard and normal duration of working time are different concepts. So are you speaking about standard or a standard duration of working time of working hours or normal duration? Second comment, if in information in the labor contract, it is necessary to indicate
могут подойти на террасу второго этажа у бассейна и записаться на массаж. Массажист Игорь Эдуардович.
Sorry for that. That was a technical pause advertising here in the facility. So, about the comment, whether in the chapter where you describe remuneration, it is necessary to state the cost or the price per working hour, per hour of work of an employee. And the third comment, if someone works part-time, does the requirement to pay minimal wages apply? Or it is not necessary to stick with minimal wages, but just make it proportional?
So thank you so much for the questions. I will start by addressing the last one. As for minimum wage, of course, it's on the proportion. It means that a worker that works half a time of a comparable full-time worker that earns minimum wage, the part-time worker would have to earn at least half of the minimum wage. As for the remuneration, the information on the labor contract, the idea is that when established on the part-time employment agreement, the remuneration of the part-time worker, it should be also referred what is the remuneration that a comparable full-time work receives for the same work, in order to assert easily if the principle of the non-discrimination and the principle of pro rata temporis are being applied to that particular worker. As for the first question, normal duration of the working time is the one that is defined on the legislation. Well, there is a definition of normal working hours on the International Labour Standard, and basically it says that, as we've seen on the last training model on working time, and the concept of normal working hours is the hours that are considered to be normal by law, or where they are not defined in the law, is the ones that in excess of which workers are entitled to receive overtime, or that are considered to be abnormal in a given sector of activity or establishment. Meaning that normal working hours would be the ones that either are fixed on law. For example, in Portugal, normal working hours are 8 hours per day. It's fixed by law, but there are countries in which they are not fixed by law. In that case, normal working hours should be understood as the ones that in excess of which workers are entitled to receive overtime, or in excess of which it is considered an exception, customs, and to the practices of a given sector of activity or establishment. I hope I responded properly to your questions, Yuri. Over to you, Sofia.
Thank you, Antonia. I hope that Antonia has answered your question about normal working hours. Now let's move on to cases, and I pass the floor to Antonia to present the first case. Please try to be attentive and join the discussion on the first case. The floor is yours, Antonia.
So the first case is pretty straightforward. It's a case of Julia. Julia is a high qualified certified accountant that has a experience of 10 years, a relevant experience of 10 years, 4 of which within the current employer. She works part-time in this company in order to have time to take care of her 2 kids. She has a working schedule from Monday to Friday from 2 p.m. to 6 p.m. She earns a basic salary of $500 per month. And she recently realized that her 2 colleagues earn a basic salary of $1,400, and they do precisely the same job as she does. The only difference is that their working schedule is from Monday to Friday from 9 to 1 p.m. and from 2 p.m. to 6 p.m. And in this case, they have less qualifications than she has, and they have only 5 years experience, and of which only 2 in this company. So they have less qualifications and less seniority, and they earn per month $1,400, whereas Julia only earns $500. So she was a bit shocked about it. So she brought it to the attention of her employer, and asked her, how come it's possible that they earn $1,400 and I just earn $500? And the employer justified that she was just a part-time worker. So my question to you, and I hope that you share your thoughts with us, is considering the data of the case, in what concerns Julia's remuneration when compared with her 2 colleagues, comparable full-time workers. And I would even say that I have doubts that they could be considered comparable full-time workers, because when you take into account their seniority and their qualifications, you will see that they are less qualified than Julia, and they are also less. They have less seniority than Julia. But anyway, we can leave it that way. So my question is, considering her remuneration when compared with these 2 comparable full-time workers, and taking into account the international labor standards and the European directives that we have seen, what do you think about it? So over to you, Sofia.
I see that on the chat box we have some comments. So I see colleague comment from Olena Yatsenko that the colleagues work full time and they even work overtime, 5 hours a week overtime. And if this remuneration is set in the labor contract, maybe it is not violation if they have that in their labor contract with the employer. There is a question if working in 2 parallel jobs and working part-time are the same concepts are different, because some people say that it is probably different. It is not just about part-time. Then Evgeny also insists on that this is not that this is part-time working schedule. Toma Bilko says that it is violation of Directive 97/81 regarding remuneration. Any other comments for this case? Now it seems that we don't have comments. Let us take 3 more seconds if you have any other ideas regarding that. So the remuneration is lower, then it should be, there is no principle, no respect for principle of proportionality, and this is actually not parallel work. Also, somebody says that Yulia should receive extra payment or bonus for her qualification. Mr. Sukharukov doesn't lacks information about her labor conditions, but actually everything that we know is presented on this case. We cannot add anything there. And that seems to be it. Somebody requests the text of the labor contract, then it would be clearer. Okay, Antonia, this is more or less it. So people say that it is a violation of proportionality principle for remuneration. And I ask you to summarize information on this case based on what you have heard. If everything is right, maybe something is missing. The floor is yours.
Thank you, Sofia. First of all, address the comment of a participant regarding parallel work and part-time work. Well, parallel work is when a worker has more than one employer, has more than one job. Of course, if you have two part-time works, different part-time works, is easier to have parallel works, because you can work part of the day in one employer and another part of the day in another employer. It's not the same concept. Parallel work is having one or more than one employment relationships at the same time, but in different working times, in different working, is having 2 or more employment relationships simultaneously in different working time schedules. As we have seen on the second module of our online training marathon, worker has the right to have parallel employment, and the employer cannot forbid a worker to have parallel employment unless national legislation foresees some exception, and those exceptions has to do can only be on the grounds of occupational safety and health issues, confidentiality issues, the integrity of public service, and conflict of interest, and only if that is foreseen on the legislation, because if it is not foreseen, the employer cannot prevent a worker from having parallel jobs. Part-time work is another story. Part-time work is when you have an employment relationship that which working period, working time is shorter than the one that is than that of full-time work in comparable situation, which is a different concept. Of course, when you have a part-time working relationship, it more easily allows you to have another employment relationship or a parallel work. So, as for the case that we are discussing, my comments are pretty straightforward, and I think they are aligned with the general comments that Sofia shared with us. So, Julius is a part-time worker which receives a basic salary of 500 per month, whereas 2 comparable full-time workers with less qualifications and less seniority receive 1,400 per month. So, Julia should receive at least 700 per month, which is the basic salary of the comparable full-time workers when calculated in proportion to her working time. It means that that would be what would result from the application of the pro rata temporis principle to the salary that the comparable full-time workers earn. So this violates, of course, Article 5 of Convention 175, as she receives lower basic wage than comparable full-time workers when calculated on proportion of her working time. And this also violates Clause 4.2 of the Annex to Directive 97-81, because the principle of pro rata temporis was not applied. In addition, this situation also configures a discrimination of Julia in relation to full-time workers, because, as her employer put it, she receives less because she's just a part-time worker, thus violating the principle of non-discrimination, which is foreseen on clause 4.1 of the Annex to the Directive 97-81, that states that part-time workers shall not be treated in a less favorable manner than comparable full-time workers solely because they work part-time, and also is foreseen on Article 4 of Convention 175, which foresees that part-time workers should have the same protection afforded to comparable full-time workers in respect of the discrimination in employment and occupation. So these are mainly the comments that this case suggests, and I would propose to move to the case number 2. Case number 2 refers to Sofia. Sofia is a medical student who works part-time as a sales representative in a pharmaceutical company. Well, she earns a basic salary of $700 per month and works from Monday to Friday from 9 a.m. to 1 p.m. She realized recently that 3 of her colleagues that are full-time sales representatives, so they have exactly the same function as she does, were scheduled for a training on a new product for which she was not invited. So she confronted the Human Resources Department about it, and she was told that she was not invited because the company feels that there is no point on investing on her because she's just a part-time worker. So, quid juris? So my question to you is, well, considering the data of this case, and specifically the fact that Sophia was not invited for the training because there was no point on investing in a worker which just works part-time, and taking into account the international labor standards and the EU Directive 97-81 that we spoke about before, what do you think about it? So, Sophia, over to you.
Thank you, Antonia. I suggest that you activate on the chat box. At the end of this discussion, we will name the leaders. We need to know our heroes. First comment from Lyubov Ivanova that this is discrimination, discriminatory treatment. Sophia has limited opportunities for her professional development. Any other ideas? Someone who works part-time has right to studies, according to Tamara Belko. Svetlana Holopura mentions that it is violation. Now, Mr. Sukharukov sees the situation more broadly. He believes that we need to take into consideration the concrete contract provisions, whether it is impossible for Sophia to attend this training because she is a student at the university. Olena Yatsenko believes that it is violation of Directive 97. Yevgeny Khostuminsky believes that it is obviously discrimination. However, training may or may not be available under labor contract. Again, there is a question about parallel employment or part-time employment in this case. Vitalina Karpushka has a question about the right to studies of this right needs to be included into her labor contract. If it is not included, it is discrimination. Ms. Sidoryak, Sophia doesn't have her main job. She is a student. And of course, professionals, our experts would like to know more detailed information about this case, but this is everything that we have. So definitely it is discrimination. These are key comments. Actually, again, we have some confusion about parallel employment and part-time employment. I believe, by the way, it is about translation. Because in the Ukrainian version of the slides, you have it translated as, you have part-time translated as parallel employment on your slides. So maybe this is why the confusion. Okay, that's it. And now, Antonia, I invite you to summarize.
Okay, thank you, Sophia. As we all understand, Sophia, a part-time worker, is being discriminated in relation to her three colleagues, which are three comparable full-time workers, because she has no granted access, she was not granted access to training on the grounds precisely that she was a part-time worker. This situation obviously violates the obligation of employers to facilitate access of part-time workers to vocational training, which is foreseen on clause 5.3d of the annex to Directive 97-81. In addition, it also violates the principle of non-discrimination, which is foreseen on clause 4.1 of the annex to Directive 97-81, that states that part-time workers shall not be treated in a less favorable manner than comparable full-time workers solely because they work part-time. And also, this non-discrimination principle is also foreseen on Article 4 of Convention 175, that foresees that the part-time workers should have the same protection afforded to comparable full-time workers in respect to discrimination in employment and occupation. And that is basically the comments that this slide suggests from my side. So I would suggest to move to the third case. Third case is about Lyudmila. Lyudmila works in a shop for 4 years. She had a full-time job on that shop. She had a full-time job there, but unfortunately, her mother got sick and need home care. So for the last 2 years, since her mother got sick, she's working part-time. She works from Monday to Friday from 9 a.m. to 1 p.m. And she was the one that requested to the employer to move her from a situation of full-time to a situation of part-time. The problem was that her colleague that also works part-time on the same days that she does, but from 2 p.m. until 6 p.m., quit her job. So her employer proposed her to resume work in a full-time basis, as she'd done before 2 years ago. But she refused because her mother is still sick and she needs to take care of her. But then her employer threatened her to dismiss her if she doesn't accept the transfer to full-time work. So quit juries. My question to you is, considering what we have heard about international and European labor standards on part-time, can the employer force her to move from a situation of part-time to full-time? And can he threaten her, or can he really dismiss her upon her refusal to move from a part-time work situation to a full-time one? So the floor is yours, Sophia.
Thank you. And let me immediately switch to comments. I believe that they are very much to the point. It cannot be grounds for dismissal, at least it must not be the main grounds. Then, according to the directive, transfer should be voluntary. And if she refuses, she cannot be dismissed. And then, sure, the employer needs to provide her with the opportunity to work part-time. It is possible to refuse to be transferred to full-time, but she needs to come up with some proof, with some documents. So all in all, the participants believe that this refusal, Lyudmila has the right to refuse to reject this offer, and it doesn't give the grounds for the employer to dismiss her. The key comments of the participants are about that there should be the voluntarity principle, so voluntary transfer is only possible. If Ludmila rejects the offer, she cannot be dismissed based on that. Of course, she cannot be threatened. In this case, sure, the employer has no right to dismiss Ludmila. Okay, the floor is yours, Antonia, to summarize this case, and then we go on.
Thank you, Sophia. So, regarding the case, and well, I think it's you are right in your assessments. First of all, of course, moving from full-time work to part-time work or vice versa should be voluntary. That is really what is said on Article 10 of Convention 175, according to which transfer from full-time to part-time work or vice versa is voluntary. As such, Ludmila has the right to refuse being transferred from part-time to full-time unless, and that is important to stress, unless the period of her transfer from full-time work to part-time work has expired. Imagine that when she moved from full-time to part-time, there was a period in which she should work part-time, and on the end of which she should resume full-time. If that is the case, she has to resume full-time, is an exception. And also, unless resuming full-time work at the employer's request is foreseen on her employment agreement. If it is not foreseen, she has the right to refuse it. Finally, the employer cannot dismiss Ludmila on the grounds that she refused to resume full-time work, because as foreseen on clause 5.2 of the annex to the Directive 97/81, a worker's refusal to transfer from full-time work to part-time or vice versa should not in itself constitute valid reason for termination of an employment relationship. So this is basically what I think it's really important to say regarding this case. And if you are okay with that, I would propose to move to an additional module that we prepare for you on telework. Sophie, over to you.
Thank you, colleagues. And now let me quickly find this presentation for you to share the screen with you.
So, as for telework, as you can see on slide number 3, telework might be defined as a form of organizing or performing work using information and communication technology in the context of an employment relationship where work is carried out away from the employer's premises. This is roughly the definition of telework that you can find on the European Union Social Partners Framework Agreement on Telework, which was signed on July 2002. Well, everybody more or less are familiar with the advantage of telework. For the employers, first of all, it allows a more flexible and efficient organization of the work and the resources at his disposal. Might that be premises, might that be human resources, might that be equipment, and also it allows employers to better adapt the work to business and to workers' needs. As for employees, well, telework allows them a better balance between their work and personal and family life. It also allows the access to labor market of workers with family responsibilities, and also it is particularly adapted to vulnerable group of workers, in particular to workers with disabilities. And as the current times taught us, it also helps to avoid the exposure of workers to risks to their safety and health at the employers' workplaces, at the employers' premises. As we all were taught in recent times, telework is really a form of organization of the work that allows to ensure physical distancing between workers, and as a result of that, it is being applied as a way to prevent the coronavirus contagions within the workplaces. So that's why, by the way, we have decided to include this new module on our online training sessions. So, but as it happens with part-time, telework has also raises also some challenges and some concerns, not only in Ukraine but worldwide. That's why there is some international labor standards and EU standards regarding telework. So, and what are those main concerns? As you can see on slide number 5, first of all, they have to do with the need to ensure the equality and non-discrimination of the teleworkers regarding in relation to the workers that work regularly at the employer's premises. It has to do also with the voluntariness and reversibility of the situation of telework. It has to do also with the need to ensure that the teleworkers are provided with needed information regarding the main aspects of their telework employment relationship. It also has to do with the need to ensure that teleworkers have access to training, because they need training. The fact that they work in a place other than the employer's premises does not mean that they don't need training and advancement opportunities on their career also. So it also raises challenges regarding the stipulation concerning the use of the work instruments and their expenses. Who provides the work instruments? Who owns the instruments? Who ensures the maintenance and the payment of the expenses concerning the work instruments and they use? There is concerns that are suggested by this new form of work. Other concerns regards occupational safety and health, because the fact that a worker is working away from the employer's premises does not mean that the employer does not have the same obligations regarding the insurance of the health and safety of the workers. Those obligations are the same. This type of work also raises challenges in which regards the privacy of the teleworkers, especially when they work in their own homes, in their domiciles, and also concerning the personal data. It also generates concerns regarding the exercise of their collective rights, and also it also raises some challenges regarding the prevention of the isolation of these workers regarding the other workers of the organization. As you can see on slide number 6, these concerns generated the need to develop some international and European labor standards in order to ensure that these challenges are correctly addressed. And those the main international labor standards and European labor standards on part-time work are based the Homework Convention number 177 of the ILO of '96, which was not, by the way, ratified yet by Ukraine. And of course, this Homework Convention is only applicable when the telework is provided within the home of the teleworkers. Moreover, it should be also referred the Homework Recommendation number 184 of also '96, which also details some aspects of this on the implementation of this convention. And finally, it is worth to mention the European Union Social Partners Framework Agreement on Telework, which was signed on 6 July 2002, and which regulates the telework in the European Union countries. So basically, as a result of the main provisions of these international and EU labor standards, when it comes to regulate at national level the rights and obligations of teleworkers, it is important, first of all, to precisely define the concepts of telework for one side and the concepts of teleworker for the other. So, according to these standards, telework might be defined as the provision of work within a context of an employment relationship carried out away from the employer's premises on a regular basis and through the use of information and communication technologies. That might be a suitable definition for the concept of telework. As for the teleworker, well, teleworker is any person who carries out telework. It is also important to regulate at national level, as it happens with part-time and in which regards any employment relationship, in accordance with the EU directives 91-533 and directive 2019-1152, is also important to ensure that at national level it is foreseen on legislation the obligation of the employer to provide information to teleworkers regarding the essential aspects of their telework employment relationship. The ideal situation would be to ensure that the telework employment agreement should be done in writing and should contain the information that is displayed on slides 8 and 9. Namely, the identification, signatures, and domicile or headquarters of the parties, the activity to be provided by the teleworker with express mention of the telework, of the adoption of the telework scheme, and the remuneration of the teleworker include not only the basic salary, but if any other components of his remuneration, and the frequency and the method of payment. Also, it is important to include the start date of the telework employment relationship, and on the case that the telework employment relationship is done for a fixed term, so its duration and end date. And it is also important that employers provide information to teleworkers regarding the situations in which when the period foreseen for telework is less than the foreseen duration of the employment contract, it should be specified what is the activity that will be provided by the telework after the end of the telework period. Moreover, it should be the teleworkers should be informed about the duration and conditions of their probationary period, if any. Also, it is important to ensure that on the employment agreement or in the information that should be provided to the workers in writing, it is specified the ownership of the working instruments, as well as the person responsible for their installation and maintenance, as well as for the payment of the inherent consumption and use costs. Also, it is important to stress, to provide information on the identification of the establishment or department of the employer to which the worker is connected, in which the worker is integrated, as well as who should the worker contact in the context of the provision of his telework. Moreover, as you can see on slide number 7, it is also important to provide information on if the work pattern is predictable, on the weekly working schedule of the teleworker, and if any, what are the arrangements for overtime and for shift work. On the other hand, if the work pattern is mostly unpredictable, well, teleworkers should be informed about the number of guaranteed paid hours and the remuneration for additional hours in relation to the guaranteed ones. You should also receive information regarding the reference hours and days when the work may be required, and also on the minimum period of notice before the start of work and the deadline for its cancellation. In addition, you should also be informed about his entitlement to training, the amount of paid leave to which he is entitled to, or the way it should be determined. He should also be informed about the procedures for termination of the employment relationship, or these documents or this information should refer to the applicable legal provisions. And also he has to be informed about the applicable collective agreements, if any, and regarding the social security institution that will receive the contributions. It is important that the national legal framework foresees that in case of a worker previously attached to the employer, the initial duration of the contract for subordinated provision of telework may not exceed some time limit, like 3 years, 2 years, 4 years, or the period laid down on a collective agreement, if it exists. It should also be foreseen that either part may terminate the contract, the telework contract, during the first 30 days of its execution, because telework is really substantially different than working on the employer's premises, and it should be considered the hypothesis of both parties, if not satisfied with the arrangement, be able to terminate this agreement and to go back to resume the previous form. Moreover, it is important to ensure that terminating the contract for the provision of telework, the workers should resume the provision of work in accordance with the agreed terms or in those provided on a collective agreement. And finally, the teleworker may start working under the scheme of the other employees of the company in the employer's premises, definitely or for a fixed period by written agreement with the employer. This is important to ensure that there is the possibility of a worker that is working from his home or from another place other than the employer's premises, the possibility to resume work with the other colleagues within the employer's premises. But in order to ensure that, it should be done by a written agreement with the employer. It should be voluntarily for both parties. As for the working instruments, and that is a particularity of telework that should be taken into account when it comes to conclude a telework employment agreement, it should be important to address the question of the ownership, of the responsibility to provide the working instruments, who should ensure their maintenance and their costs. And it should be also provided in legislation what happens if that is not provided for in the legislation. It should be considered the introduction of a legal presumption about this obligation when it is not specifically foreseen on the telework employment contract. So, in this sense, for example, on the European Union Framework Agreement on telework, it is foreseen that in the absence of stipulation in the contract, it is presumed that the working instruments relating to information and communication technologies used by the employee belong to the employer, who shall ensure the respective installation and maintenance and payment of the inherent expenses, unless the telework uses his own equipment. And this last consideration is very, very important. Moreover, the worker shall comply with the rules for the use and operation of the working instruments made available to him by the employer. And it also should be foreseen on law that unless otherwise agreed, the worker may not give to the work instruments made available by the employer different use than the inherent to the performance of his work. Moreover, in order to ensure the equal treatment and non-discrimination of teleworkers in relation to workers that work on a regular basis at the employer's premises, is also important to ensure on national legal framework that teleworkers has the same rights and duties as other workers, including in matters of vocational training and promotion of career, working time, rest periods, and other working conditions, as well as safety and health at work, protection against discrimination in employment and occupation, remuneration, statutory social security protection, minimum age for admission to employment or work, maternity protection, and reparation of damages arising from either work-related accidents or occupational diseases. This is also important to ensure that in what refers to vocational training, the employers shall, in case of need, provide teleworkers as well as to their managers and colleagues adequate training on the use of information and communication technologies that are needed for the exercise of the activity. And finally, the employer shall avoid the isolation of teleworkers. One way to do it is to promote regular contacts between teleworkers and the company and with other workers. Another concern that we mentioned at the beginning of this presentation regarding telework is the concerns regarding the privacy of teleworkers. It is important, in order to ensure the privacy of teleworkers, to provide for in national legislation that the employer must respect the worker's privacy and rest times, as well as the rest of her or his family, and provide her or him with good working conditions, both physically and psychologically. It is also important to foresee that where the telework is carried out at the worker's home, the visit to the workplace shall only have the purpose of controlling the work activity or the work instruments that were made available to the teleworker. And it is especially important to foresee on legislation that whenever the telework is performed at the worker's domicile, these visits to the teleworker workplace can only be carried out between 9 a.m. and 7 p.m., subject to prior notification of the teleworker's agreement, and with the assistance of either the teleworker or someone designated by him. That is very, very important. Moreover, and in what concerns the facilitation of the access to telework and to the labor market in general by special vulnerable groups of workers, it should also be considered to provide for in national legislation a provision such as this one that is proposed on slide number 14. Basically says that workers with a child aged up to 3 years, workers victim of domestic violence who presented competent criminal charges, and workers with disability, they should, when they do so request to the employer, should be entitled to carry out their work activity on a telework basis, provided that is compatible with the activity that they perform and that the employer has resources and means to do so. It would be very, very important. Finally, as far as the teleworkers' collective rights are concerned, and that is a concern because they are away from the workplace where the other colleagues work, it is important to ensure that fact that they work away from the employer's premises do not put in jeopardy their right to collective participation, collective bargaining, and collective representation of their own interests. So, in order to ensure that, it should be foreseen on national legislation that teleworkers integrate the number of employees of the company for all purposes relating to collective representation structures, and that they may apply for these structures. It should be also foreseen on national legislation that teleworkers may use the information and communication technologies that are allocated for the provision of telework to participate in meetings promoted in the workplace by collective representation structure of workers. And finally, it is also important to ensure that any collective representation structure of workers may use the same information and communication technologies to communicate with teleworkers in the course of their activity in order to disseminate trade union information, calls, communications, information, or other texts relating to trade unions' life and to the social professional interests of workers. So, and that is pretty much what I would like to share with you regarding telework. It was a bit telegraphic, but well, we tried to squeeze it in this already prepared module, training module on part-time. That's why it was a bit squeezed. So I hope you like it. I would suggest that we move to Q&A, but before that, I will give the floor to Sophia to check if there are any relevant comments that we should address before the Q&A, before the discussion of the case, and after addressing these comments that might have popped up during the presentation, then we will address the discussion of the case. Sophia, over to you. Thank you.
Thank you, Antonia. In the course of your presentation, there were three comments, key comments that I believe we need to discuss after your presentation to cover this topic, and then we move on to the case. So the key comments are this: that in case of telework, there are higher costs of the employee for electricity, for example, for other things, because they work in this distance mode. So maybe we should focus a bit more on that. Who needs to cover this kind of costs that are associated with telework, like electricity? Second comment, this is about OSH, that this is the key problem now that needs to be addressed and settled somehow, where people work in telework mode. As an example, Evgeny Kostyuminsky mentions that since employers are supposed to ensure OSH conditions, it is rather difficult to do that in the context of telework unless there is a settled workstation. Because today he works at home, tomorrow at a cafe or in a park. So then how would it be possible to hold the employer responsible or liable for OSH related aspects? And third question from Yuri, whether if we speak about telework, if it is important to note that the workers use ICT, or is it the requirement that the worker uses ICT to define that work as telework? So I believe these are key questions, and maybe over to you for your comments.
Thank you, Sophia. So starting by addressing the last one of Yuri, yes, the use of ICT technology is one of the prerequisites to consider the provision of work within this form as telework, because telework is really defined by the provision of work away from the employer's premises through the use of information and communication technology. So the use of these technologies is a element that is essential to characterize the performance of work as telework. As for the first question regarding the fact that teleworkers will have higher costs on their places, on their homes, if they work home, because they will consume electricity, they will consume more gas with the heating systems, etc., etc., etc. That is true, and EU framework agreement on telework foresees that if nothing is said regarding that, those costs are a responsibility of the employers. And in order to avoid any confusions, that should be included on the telework employment agreement. Who is responsible for providing the work equipment, the information and communication technologies, as well as to pay for the costs of, I don't know, printing cartridges, electricity, heating, paper that will need to be used, etc., etc., etc. It should be clear to both parties on the employment relationship who is responsible for supporting those costs. But one thing is for sure: when nothing is said, the general rule is that the responsibility for providing the work equipment and for paying the necessary expenses, maintenance, and use is for the employer, unless the worker uses his own equipment. So it is important to define before the telework employment relationship starts what are the rules, so that there is no surprises at the end. As for the third question, yes, the principle is that, regarding us, the principle is that employers are the ones that are responsible to ensure at all times the health and safety of the workers in all aspects related to the workers. That is said on the EU WASH Directive 89-391, and that applies to telework also. And it applies to telework also via the provisions on the non-discrimination of teleworkers in relation to other workers that work on employer premises. So, in the case of teleworkers, the employers are equally responsible for ensuring the health and safety of the workers in all aspects related to the work. But as the person that comment on that reform is a bit difficult because the employer is not there. So it means that in order to ensure that, the first thing to do is to assess the risks to which the teleworker is exposed. That is the first step in any occupational safety and health management system. Assess the risk and then define the preventive and protective measures that are most suitable for the risks that are in presence. And we already talked about some risks, psychological risks, due to isolation, to extended working hours, to difficult to compatibilize family life with working life, etc., etc. The right to disconnect, etc., etc. So these risks has to be assessed, and resulting from this risk assessment, employer has the responsibility to implement the necessary preventive and protective measures. And of course, as it happens, if the work was working at the employer's premises, the worker also has the obligation, the legal obligation, to cooperate and to collaborate with the employer on the risk assessment and also on the implementation of the preventive and protective measures. And that's pretty much it, Sophia. Over to you.
Thank you. So while Antonia was commenting, there were no new questions, and I believe to complete that, let us switch to the case, actually. And let us discuss this case, and then we move on. And please, if you still have some outstanding questions, there will be a couple of minutes for that. Now let's see the case.
Thank you, Sophia. So this case is about, of course, telework. Let me present the case. So Marco joined a software company 2 years ago as a teleworker IT specialist. He earns $2,000 per month. He works from Monday to Friday from 9 a.m. to 1 p.m. and from 2 p.m. to 6 p.m. Recently, his computer crashed and the computer is beyond any repair. So he asked his employer, he talked with his employer, and he asked his employer to buy him another suitable computer so that he could work. But the employer replied that it was a Marcus problem. He has to solve it. He has nothing to do with his computer. Well, Marco was worried, so he looked at his telework employment contract, but he realized that his contract does not have any mention whatsoever, contrary to what it should, to the ownership or the responsibilities regarding the maintenance and the payment for the work instruments and work equipment. So my question to you all, and I hope you participate actively on this discussion, is considering what we have seen regarding the international and European labor standards on telework, especially in what concerns the responsibility for ensuring, for providing and ensuring the work equipment and instruments maintenance and payment, what do you think about the situation of Marco? Should he be responsible for repairing his computer, or in this case, in which the computer is beyond any reparation, to buy another one, or should that responsibility be of his employer? So, quid juris. Over to you, Sofia.
Here I see several comments. First comment is this. All of these details need to be included into labor contract. Then, if in the contract nothing is mentioned, a priori it should be a problem of the employer. So the employer must ensure repair of the equipment. Same from Mr. Sukharukov. If it is not indicated in the contract, it is up to the employer to resolve this problem at the cost of the company. Then comments on details that it is necessary to find out why the computer broke down, whether it was a problem of the employee or it was normal course of events. In line with Convention 177, the employer needs to provide equipment to the employee, and Valery believes that this is the problem of employer and it needs to be covered by the employer. Any other ideas on that? The provisions need to be included into the contract. Again, costs on the employer, Yulia believes. These are key messages, Antonia, for our case. So, Antonia, this is opinion of our participants, and now floor is yours to summarize.
Okay, so I agree with most of your comments. In fact, the conditions regarding ownership, payment of the expenses, and the maintenance of the work equipment and the instruments, as well as the expenses regarding electricity, heating, etc., should be included on the telework employment contract. As you already have seen in the European Union framework agreement on telework, it's foreseen that the general rule, in the absence of any clause about that on the labor contract, on the employment agreement, the responsibility, the ownership of the work equipment and instruments, and the responsibility for providing its maintenance, installation, repair, and the payment of the use costs should lay down on the employer. But there is an exception there, which is unless the ICT equipment that is used is of the teleworker, which is the case of Marco. The computer that needs repair is his own computer that he uses to work. So either he put it on the employment contract that the responsibility for providing the work equipment and instruments, as well as for supporting the respective costs, is from the employer, and in this case the employer has to do it, would have to do it, or that no matter he uses his own computer, if the computer has a problem, the employer should be responsible for repairing it or substituting it. But as he didn't do it, because his contract does not have any clause about it, the general rule is that it should be insured by the employer. But there is an exception, which is when the teleworker uses his own equipment, which is the case. So Marco didn't sign any, in his contract, there is no reference regarding ownership of the work equipment or the responsibility for its installation, maintenance, etc. So it applies the general rule. General rule says that is responsibility of the employer unless the work equipment or the ICT systems are owned by the worker, which is the case. So in this case, unfortunately, if is for Marcus to either support the expenses of repair of his computer, or he has to buy a new one for himself with his own money. That's the solution of this case. So Sophia, it's about all from me. I would suggest that maybe before giving the floor to the audience for the Q&A session, I would propose to anticipate and give the floor to Andre, because it's already almost 1 o'clock, and he would make a short presentation of the specific component of this project on maternity protection, and then when Andre finishes, we would jump into the Q&A session. Over to you.
Thank you, Antonia. On my part, regarding telework, we are almost ready with the respective materials, with infographics, with the background material. It will later be available on the website. So far, it has not been finalized, so we need to wait a bit, and then information will be available. While our colleague Andrei speaks, think about your couple of questions on the topic of part-time job and telework, so that we could wrap up and answer all the give answers to all of your questions. And now we pass the floor to Andrei Figel. He is our colleague from another project. Since you have this high level of interest to maternity protection, as manifested last time, but now we will not go deep into that aspect. We will just present the opportunities, resources, people, experts who will help you to analyze this topic in more detail. So now let's pass the floor to Andrei for his presentation. Good morning, dear colleagues. Thank you, first of all, to organizers. Thanks for organizing this online marathon of trainings on international and European standards, labor standards. Thanks for active participation to the audience, and thank you for not strictly limiting the topics that you discussed to only those that you already have on your agenda, but that you in particular have touched upon maternity protection topic. I coordinate the project that is mostly focused on remuneration. This is about arrears, minimum wages, equal remuneration. But in addition to these three key components of the project, our project also implements targeted activities to develop capacity building for organizations, trade unions, associations of employers, and the government, in particular maternity issues. This topic is nothing new, neither for ILO projects in Ukraine nor for Ukrainian society in general. Maybe you know that in 2019, there was a comprehensive comparative analysis of compliance of the national legislation of Ukraine with provisions of ILO Convention 183 on maternity protection. This was a comprehensive analysis which goes article by article and generalizes whether national legislation complies with the convention. And based on practical experience, we know that this actually is what is done prior to ratification of the convention. However, unfortunately, after 2019, the convention has not been ratified, but it doesn't mean that we need to do nothing about that. So we need to support awareness of our social partners, and for that sake, we have been holding trainings last week and this week. Taking into account the specific aspects of the training, we adjusted the training materials, but the training includes such important aspects as risk assessment at work for pregnant women, protection of employment and prohibition of their discrimination, We also discussed the role of tripartite social partners there. Then we discussed remuneration, medical aid for maternity protection, and coming back to work after maternity leave. Let me emphasize that participants were actively engaged into that topic, and there is high level of interest, and I'm sure that hopefully when the convention is ratified very soon, we will already have a range of experts who will be able to join the process of implementing provisions of the convention and harmonization of Ukrainian legislation if necessary. Not to take too much of your time, let me just mention that all the training materials are available from us. These are presentations that I can share with you, and we also prepare a video material that you will be able to use. You will be able to look through that and use it for your online trainings. And I would suggest it to organizers of today's training on part-time work. If somebody wishes, we could exchange contact lists. I mean, I'm ready to pass over all of these reference materials, background materials on maternity protection. And also we have a team of national experts and consultants. We work closely with an international expert for social protection and maternity protection in particular. So if needed, I believe we will be able to organize additional trainings if necessary. And I hope this information was of use for you, and I will be looking forward to your feedback, to your requests for information, queries, and let's develop our collaboration. Thank you.
Thank you so much, Andriy. The need for the intervention of Andriy has to do with some interventions within our last session of online training, within which some of the participants addressed the questions of maternity protection and ask us specific information on maternity protection. So we talked with our colleague Andriy, which is managing a project that touches upon maternity protection, precisely to put you all in contact with him, and Andriy available himself to provide all information and materials that you need on maternity leave. So if you need any further information on maternity leave, please do contact Andriy. He's more than happy to help you. He will leave his contacts, and he will help you on that. Thank you so much, Andriy, for jumping in. I know that you have a very complicated life nowadays, so thank you so much. Sophia, over to you in order to get on with our Q&A session. Thank you so much.
We actually tried to discuss the questions after Antonia's presentations on part-time and on telework. However, I do see on the chat box two questions. One, for which period would it be possible to introduce part-time? Meaning, if there are some limitations for part-time job conditions for employees, if there are some limitations for that period. And second question, it is a bit general, maybe you would like to comment to make it more precise, but what do you think, Antonia, about 0-hour contract? Do you have any ideas about that kind of contracts in the context of the topics that we are discussing today? So Evgeny Khotsiminski actually makes it more precise regarding 0-hour contract. If 0-hour contract corresponds to the requirements regarding protection of rights of this kind of employees, if that is a special form of labor relations. And another question from Irina Sidoryak: if an employer introduces working hours as 2 hours a week, and they justify that by some transformations or changes in labor organization, if it is possible to do that, because very often the employees have to resign if they only have 2 hours of work a week. Irina actually reiterated this question, so maybe it is important to comment on that. And of course, we speak about these situations in the context of international standards. Antonia, maybe you could address these questions so far, while our participants, if they have any further ideas or questions, they will have a last chance to share them. Antonia, the floor is yours.
First of all, let's start for the last one. Regarding 2 hours, work of 2 hours per week, which by the way is also kind of related with the 0 hours contract. But first of all, regarding the 2 hours week, one thing is if a person is hired or has an employment relationship that foresees a part-time work that consists in 2 hours per week. That is possible. It's not impossible. Another story, and I think that is the question of our participant. If someone has a full-time work, and suddenly the employer says to her or to him, from now on you will only work 2 hours per week, well, that is another story, and that is serious business. Because if someone has an employment relationship, associated with that employment relationship is a working time schedule. And if a person has a full-time employment relationship with an employer, the employer cannot unilaterally reduce it to 2 hours a week, because that would imply that the employer would be changing a full-time work relationship to a part-time work relationship without the consent and the agreement of the worker, which is illegal. The changes between full-time work and part-time work and vice versa should be voluntarily and should be agreed in writing between worker and employer. So if an employee doesn't consent to move from a full-time work employment relationship to a part-time work relationship, the employer cannot do that. And we already have seen a case of that. The employee has the right to refuse it, and the employer cannot dismiss it on those grounds. As for the 0 hours contract, and we are moving to another question, well, as you know, we cannot prevent the need of employers for flexibility or the need of the workers for flexibility. What we can do is trying to balance the need of employers for flexibility with the need of workers for security, which is flex security. And that is precisely what the European Union have done with Directive number 2019-1152. It's a directive that is focused on ensuring transparent and predictable working conditions in the EU. And that directive foresees that on this type of contracts, in this type of non-standard forms of work, there should be some guarantees to the workers. The idea is we cannot prevent these new standard forms of work to appear because they have also benefits. We cannot just prevent them, but we have to regulate them in order to balance the rights of both parties, employers and workers. Because employers need workers as workers need employers. So, and in that sense, it is better to try to make the best of it than to just fight it. And the 0 hour work is not necessarily bad. It has to be enquadrated, and it has we should try to ensure that workers and employers that are involved in 0 hours contracts have the rules precisely defined, and that the need of flexibility from the employers are also compensated with the need of security for the workers. And this directive, in concrete, it establishes a lot of provisions that are aimed at doing exactly that. For example, regarding on-demand contracts, there are several mechanisms. First of all, directive foresees that there should be provisions in national legislation that limits the use of on-demand contracts, and also that when the employer fails to provide information to workers regarding this, there should be legal presumptions that foresees that the workers have an employment relationship with the employer for a minimum guarantees number of hours per week based on the average number of hours worked on a given period of time. Also, it foresees that national legislation should take measures in order to promote the access of employees to more predictable working conditions. And in that sense, workers should take into account requests of workers to move from a more unpredictable form of work to a more predictable one. So also the legislation foresees that workers should be informed about the time slots in which they should be available to work assignments, and it should be defined. They should also be informed regarding the period of time in advance that they should be informed of a work assignment and the period of time that the employer has to cancel those assignments. And also, it should be foreseen on the legislation, for example, that the worker should be compensated if the employer cancels a previous agreed work assignment. Also, the legislation foresees that employer cannot prevent the worker from having parallel employments, meaning that a worker on these situations can have other employment relationship, and employer cannot prevent an employee from having other employment relationships which working time does not overlap with the working time that he has with that precise employer. So the legislation tries to compatibilize all the interests that are dealing with zero hours contracts, and also they also foresee that the fact that someone is working on a 0 hours contract or on-demand contracts or contracts with unpredictable working time does not mean that the person does not have an employment relationship. It has an employment relationship if he works for someone to provide his work in exchange for a remuneration under his control, authority, and supervision. That is an employment relationship, whether the working time is mostly predictable or unpredictable. And also this directive also establishes that national legislation should foresee the presumption of an existence of a labor contract or an employment relationship whenever the employer fails to provide this information in writing to the workers. So, and moving to the first question about the period of part-time. I'm not sure if the question is about a minimum number of hours for a part-time employment relationship or a minimum duration of the part-time employment relationship. Either way, there is no limit on international labor standards or European Union acquis regarding a minimum working time for a part-time employment relationship. Neither there is a limit on the duration of a part-time work employment relationship. So, Sophia, I hope I addressed all the questions. I'm happy to address other questions that our participants might have. So with that purpose in mind, I give you back the floor. Thank you.
Thank you, Antonia. And now let me mention our leaders, our heroes, most active participants of the discussions. You've made our day. So this is Alexander Sukharukov, Ivanova, Karkushka, Sigoryak, Tamara Belko, Yevgen Hostomilsky, Yuri Vesemelnik, and Olena Yatsen. Thank you. You are great. In a positive way, let us pass over to Antonia.
Thank you, Sophia. So it's time for a wrap up to kind of highlight the main conclusions of this training session on part-time from one side and telework for the other. So starting on the part-time, well, I think it, as we have seen, it's a useful instrument for balancing the needs of both workers and employers. Of course, it presents some challenges that needs to be addressed at national level by national legal frameworks, and those are specifically the needs to ensure that part-time workers are timely informed about the essential aspects of their employment relationship, the need to prevent discrimination of part-time workers in relation to full-time workers, the need to ensure the application of the principle of the pro rata temporis on the calculation of the remuneration and other benefit of part-time workers with reference to the ones that the full-time workers are entitled to, but in proportion to the working time of the part-time workers, and also the need to facilitate the voluntary transition from full-time to part-time work and vice versa. As for teleworker, well, I think it is also fair to recognize that telework is really an important instrument of flexibility that allows balancing the interests of both employees and workers. But as it happens with part-time, it also needs to be regulated at the national level in order to address the risks that we discussed before. In particular, it is important to ensure that the teleworkers are informed about the main aspects of their employment relationship. It is important to prevent discrimination of teleworkers in relation to the workers that works at the employer's premises. It is also important to ensure the voluntariness and the reversibility of telework arrangement. National legislation should also regulate the provision of the work instruments and their installation, maintenance, and payment of the inherent costs. It is also important to ensure that the privacy of teleworkers are and the right to personal data are really ensured, and finally that their collective rights are also ensured and are not jeopardized just because they are teleworking. Finally, I have to thank you all again for your very constructive comments and the participation on the discussion of the cases and on the Q&A session. You are terrific. You are fantastic. It's a pleasure to share these themes and discuss these themes with you. And well, I hope that we can meet again on next Thursday, 23rd of July at 11, as always. And this next training session module will be on labor inspection. That will be an interesting discussion, I hope. So I hope to see you all there. Don't forget to register and join us. Thank you so much. Goodbye.
And colleagues, to wrap up, let us do this challenge again. Let's try to see all the 1,500 of labor inspectors next time. This is a relevant topic. We are speaking about decent labor. Let's see employers. Let's see representatives of trade unions. So I hope that we will be like 2,000 next Thursday. So hugs. And see you all to discuss labor inspectorate next Thursday.